May it please the court, I'm John Heflin of the Memphis Bar. I'd like to reserve 3 minutes for rebuttal.
3 minutes, okay.
My client is Jenny Vergos, the plaintiff below, who asserted both an individual claim and on behalf of her husband's estate, a claim both against Charlie Vergos Rendezvous, Inc., which I'll call CVR, based on commitments CVR made in signed writings. The first of those claims is Jenny's individual claim for unpaid annual benefits assigned by her husband to her pursuant to the terms of a 2006 amendment to a 2004 shareholder agreement that CVR started paying to her after her husband Nick's death in 2019, but stopped paying her the next year on grounds that the COVID pandemic had temporarily closed the restaurant, but never has resumed paying. Now, the trial court did not reach the merits of that claim because it erroneously, in our view, held, one, that Jenny lacks standing to sue CVR, two, that shareholder agreements are not binding contracts, and three, misread the 2004 shareholder agreement as prohibiting Jenny from benefiting in any way from CVR stock. Addressing those three findings in order, first of all, Jenny did in fact have standing to sue CVR. The Tennessee Supreme Court last year in the case of Wilmington.
Mr. Heflin, let me pose a question to you. How did these actions wind up in the probate court?
Your Honor, they were originally filed in Chancery Court, and the trial judge in probate said after we had some motions in the estate proceedings that he was going to request that the chancellors transfer those matters down to him so that all matters involving in any respect the estate would be heard by the probate court. That's what happened.
Was there any objection to that?
Your Honor, frankly, there was no motion. It was done sua sponte. It was announced that it had been done. I did some research on that issue, and it appeared from my research that there is substantial law that Chancery Court and probate court have concurrent jurisdiction over matters involving an estate. And there's case law talking about how the chancellor and the probate judge have discretion as to who's going to handle that. So it was looked at. There frankly was no motion. I suppose I could have objected afterwards after it was done, but it was a fait accompli. It was announced it was being done.
Thank you.
The second point.
Let me ask you, did you review those ordinances that were cited in the motion transferring the case to probate court?
There was no motion. There was simply an announcement by the probate court judge that he was going to have the matters transferred down to probate court. Then there were orders of transfer entered in Chancery Court without anybody appearing.
Did you look at what was cited as authority for that included in the order?
I frankly don't have those orders right in front of me. I did look independently at the authority that I just referred to, and it appeared to give the Chancery Court judge and the probate judge discretion as to those matters, as to who would address the matter.
And you found that authority where?
I found it.
What's the authority for that?
Your Honor,
You
I
say
can cite
probate.
that. I brought it with me. The authority to that is there is a 1935 private act that gives the court, quote, concurrent jurisdiction with Chancery Court to determine controverted issues in cases involving executors. And then there's a 1989 Court of Appeals case of Bishop versus Young, which has the language about the discretion in the Chancery Court and among the Chancellor and the probate court judge as to who will address those matters. And we did look at those.
Yeah, and this contract action was not against the estate, was it?
It was not. Well, they're both contract actions. The individual action was not, and is an individual action not an estate proceeding.
So it was not really a state proceeding, was it?
It was not, they were in the same, they were in the same lawsuit.
No, the action that the widow filed against the remaining shareholders of CVR and CVR is not an action against
That,
the
you're
estate.
exactly right. Your Honor, I was referring to the two claims that are at issue now, the separate action brought against the two other shareholders, the two officers, John Vergos and Tina Vergos, does not involve the estate.
Okay, all right.
The second point is that the trial court didn't reach the merits of that claim because the trial court ruled that shareholder agreements are not binding contracts. But that's directly contrary to Tennessee
Let me ask
Code.
you, did you get a different ruling from Chancery Court about whether or not this was a contract action before the case was transferred?
No, Your Honor, nothing happened other than the probate judge announced that those matters were going to be brought down to probate court, and promptly thereafter, we received orders signed by the chancellors transferring. My only presumption is that the probate judge contacted the chancellors and told them that, or requested of them that they transfer the matters down. It was
there an
done
order?
without counsel's involvement.
Was there an order entered by Chancellor Jenkins in 2022 that said that this was a contract action and that your client had a right to bring that action? You recall that 2022 order entered by Chancellor Jenkins?
Correct. There was an order entered by Chancellor Jenkins and also an order entered by Chancellor Kyle, if I recall correctly.
That said exactly what I just said?
Correct.
Okay, all right.
The second point I was making was that Tennessee Code 4817-302B expressly recognizes the binding effect of shareholder agreements, saying, quote, saying that no shareholders agreement, quote, shall be invalid as between the parties thereto on ground that it is an attempt by the parties thereto to restrict the discretion of the board of directors in its management of the business. So they are valid. They're just like any other binding agreement on the parties. Third, the trial court misread the 2004 shareholder agreement by saying that it prohibited a spouse like Jenny, my client, from benefiting in any way from the shareholder, from CVR stock, when Section 502B of the 2004 shareholder agreement, which is quoted completely in the record, expressly permits a lineal descendant of Charles Vergos to place CVR stock in trust for the benefit of his spouse. Turning to the merits, I think it's important to recognize that both parties stated that the material facts were undisputed and that summary judgment was appropriate. CVR recognized the validity of the 2006 amendment when it started making payments. It only made one argument below for saying that it had no liability, and that argument was first breach. And first breach is an affirmative defense that was not pled. And of course, the rules provide that if it's not pled, it can't be asserted. But furthermore, if you look at, separate and apart from it not being pled, if you look at the 2006 agreement, it placed no obligations on Jenny at all to do anything. There's no competent evidence of any violation of any duty under that agreement. Now, in addition to that first breach argument, which was not pled, CVR argued three ways to try to reduce its liability. First, it alleged that it canceled the agreement, the 2006 amendment, by the votes of the then shareholders in September 2023. But the 2006 amendment has no provisions for its amendment or cancellation, so the 2004 provisions apply. And that says, quote, this agreement may only be amended by an instrument in writing duly executed by all of the parties to the agreement. The words all of the parties to this agreement could hardly be clearer. And in the same provision, there is a separate sentence that deals with, not with amendment of the agreement, but with termination of the agreement. And it permits termination of the agreement, which would be termination of all of the restrictions on the transfer of CVR stock, which the existing shareholders of CVR don't want to do, by the then existing shareholders. CVR argues in its brief, well, the power to terminate includes the power to amend. Well, it doesn't include the power to amend where the provision differentiates between the two and says the power to amend can only be done by, quote, an instrument in writing duly executed by the parties to this agreement. It means what it says. The CVR next argued below to the trial court that its liability to Jenny should be reduced by distributions made to Nick's estate and to his trust. And they rely upon a sentence at the end of paragraph 3 of the 2006 amendment that says the parties agree and acknowledge that distributions to shareholders in respect of their stock will be reduced by the amount of the annual payments. This has no application to Jenny, who is not a shareholder. Furthermore, the sentence says distributions to shareholders will be reduced, not that the annual payments will be reduced, but below CVR was arguing, let's reverse what that says. And of course, that's not what it says. Now, it's in its appellate brief, CVR makes an argument not made below that the sentence invalidates the entire 2006 amendment. But that's not so. Nothing in that sentence requires unequal distributions per share to shareholders. And it says distributions to shareholders, plural, will be reduced by the annual payments, which is precisely correct because those annual payments would reduce the amount of distributable profits distributable to shareholders. So, and furthermore, when CVR was paying Jenny in 2019, it had, right after Nick died, it had no problem with that provision. It contended that it has only come up with that argument as a justification for never resuming the payments. My light just went off and I'll reserve my 3 minutes. Thank you.
Thank you.
Good morning, Your Honors. May it please the Court. I, along with my colleagues Sarah Stewart and Jeff Feibelman, have the honor of representing Charlie Vergos Rendezvous, the corporate entity that operates the world-renowned family-owned downtown Memphis restaurant, The Rendezvous. We're here today not about sibling dynamics.
Could you tell us who you are? Could you tell us who you are?
Yes, sorry, I'm Jennifer Hagerman. Nice to be here today.
Thank you. And in that same vein, could you enlighten us? You go ahead and start, Angie. Could you enlighten us any further as to how the probate court obtained these cases and resolved them? Mr. Heflin may have explained everything there is to explain, but we're all curious about it.
Your Honor, we had some proceedings, as Mr. Heflin indicated. I think the probate judge expressed some frustration about the length of time that the estate had been open. Nick Vergos died in 2019, and this was still going on well into 2022, and that required the estate to remain open. And at that point, he inquired as to the status of the litigation in the Chancery Court, and the Chancery Court in Shelby County, as you may know, is very busy and has a full docket. And Judge Townsend indicated that he had the capacity on his docket to move the case along very quickly and would be willing to do that, and asked the parties if they had any objection to that. There was no objection expressed in front of Judge Townsend. He agreed that he would reach out to Chancellor Jenkins and talk to him about the possibility of transferring the case, as well as Chancellor Kyle. I don't represent the parties in the matter involving Chancellor Kyle, so I'm not really clear exactly on the facts involving that matter. But my understanding is that Chancellor Jenkins agreed that transfer was appropriate, and the case was transferred pursuant to orders of the courts.
Okay. Thank you.
You said it was transferred pursuant to what?
Orders of the courts.
Orders of the court, okay. And the authority cited for the transfer was what?
I believe, Your Honor, there are statutory provisions that permit in Shelby County the courts to transfer matters and to have concurrent jurisdiction. That was our understanding.
And is that by way of the Shelby County ordinance? Is
That's
that what
my-
you're citing?
That's my understanding, Your Honor. And we consulted with the probate attorney in our office regarding this matter to make sure that this was an appropriate action for the court to take, and our understanding was that this was something that occurred from time to time when there were litigation matters that were causing estates to remain open for long periods of time, and therefore the action by the probate court was appropriate. I think notably here, Your Honors, there was an opportunity to object or express some sort of disagreement with Judge Townsend's, proposal for the transfer of the cases, and there was no objection that was expressed, and therefore the parties moved forward with the litigation in front of Judge Townsend. There was never any sort of motion filed. There was never any effort to bifurcate the claims, to have the claim against the estate proceed in probate and the individual claim proceed in chancery. The case was fully litigated through summary judgment in front of Judge Townsend, including things like having hearings on motions to compel.
The claim that we're reviewing today, is that a contract claim that was filed against parties other than the estate?
Your Honor, there's two contract claims here. One is filed by Ms. Vergos in her capacity as executrix for the estate. And then the second contract claim is filed in her individual capacity. So she brought both of those claims in one lawsuit that was filed in chancery. And then she also has a promissory estoppel claim that is also in her capacity as executrix.
Is the estate a defendant in either one of those claims?
No, Your Honor. The state is only a plaintiff.
Okay, all right.
Go ahead.
Your Honor, wanted to respond directly to a few of the issues that Mr. Heflin brought up, and most importantly, the issue of standing. I think that the trial court, when considering this case, looked at it from the perspective of the importance of honoring the stock restrictions and shareholders' agreements, and especially the importance of also honoring the business judgment of boards of directors. When he looked at the shareholder agreement and also looked at the 2006 amendment, I think he correctly noted that the annual payments were in fact a form of distribution. And Mr. Heflin's own argument reflects that in the sense that he suggests that the distributions to all the shareholders should be reduced by the amount of the annual payment his client seeks. Well, in doing that, he's acknowledging that Ms. Vergos is in fact receiving a direct distribution, that the annual payment is nothing more than a distribution because it is in essence taking distributions from the shareholders and moving those distributions to Ms. Vergos, something that is clearly directly moving them to Ms. Vergos, something that is clearly not permissible under the shareholder agreement. The shareholder agreement only permits her to receive distributions or own shares if she does it through a qualified trust. And the qualified trust must have a trustee that is either a bank or a lineal descendant. And those things were not happening. And I think that what happened here is the court recognized this and recognized that that rendered this 2006 agreement unenforceable, and therefore concluded that she did not have standing to proceed on this claim. In terms of the argument regarding the 2003 termination, I believe Mr. Heflin is choosing to read the shareholder agreement in the way that best benefits him. The term parties is not defined by the shareholder agreement, but when you look at the shareholder agreement in context, you can see that the term parties was clearly meant to refer to the shareholders. The shareholders are the party to the agreement, whoever the shareholders are at that time. And that's made particularly clear because permitted transfers are allowed, and a permitted transferee then becomes a party. Under Mr. Heflin's reading, once the shareholder agreement is in place, you can't amend it, but except for by the exact parties to the agreement at the time it was entered into. And I think we can all agree that that's an illogical result, is to not allow shareholders the ability to amend their own document. The only thing they could do, and he acknowledges this, is terminate it. Well, the shareholders here, I think, were permitted to amend the shareholders agreement. That's exactly what they did. They entered into the 2003 amendment, and they did it not in their own interest. And I think that's clear here too, that the business judgment rule is at play. They're not acting in their own interest, they're acting in the best interest of the corporation. They're doing what they felt was best for the future of the company. In terms of Mr. Heflin's argument about first breach, I think that his position that Ms. Vergos was to get all the benefit of the 2006 amendment and have no consequences related to it reflects back on the standing position. You know, she was seeking this entitlement to payment, but didn't want to be held to have any responsibility to the company at all. She wanted to benefit from the direct distributions flowing through her through an annual payment, but didn't want any obligations. And to be clear, our claim about first breach is that Mr. Vergos committed a breach of this agreement, and he was clearly a party to this agreement. Mr. Vergos, it's undisputed, as Mr. Heflin said, there's not any disputed facts here today. These are cross motions. It's undisputed that Nick Vergos shared confidential information, including financial information, with direct competitors of the Rendezvous, which is clearly a breach, and it is not an argument we waived. We argued below that these breaches had occurred, and it wasn't until discovery that we realized the extent of Mr. Vergos's breach. With regard to the bonus claims, I'd like to point out that the trial court's ruling was also correct on these claims. Nick Vergos was an at-will employee of CVR. He had no employment agreement. He could be terminated at any time. He didn't consent or otherwise agree to his suspension, and he expressly dissented from the 2015 written consent in writing. And he was informed in May of 2016 that he would not be receiving these bonuses, and he never placed the bonus payment at issue or asserted any sort of claim for these bonus payments. The fact that he directly dissented from his suspension in writing on the 2015 written consent reflects that there was no mutual assent or meeting of the minds to create a contract here. In addition, there was no consideration. He didn't do anything and was not under any legal obligation to do something or refrain from doing anything that he had a legal right to do. There's no dispute that he didn't agree to his suspension and he had no choice regarding it. So we also have a lack of consideration on that contract claim. And the promissory estoppel claim fails for a similar reason. Mr. Vergos did not rely on any promise to his detriment. There was no reasonable reliance here sufficient to establish the claim for promissory estoppel.
The 2015 agreement, was that a board, you call it a written consent, was it a board resolution?
It's actually, Your Honor, entitled Written Consent of the Board of Directors.
And why is it titled written consent? Is that because they consented to waive the notice requirement of a board hearing?
That was part of the action set forth in the written consent. Yes, it was done by written consent because they were not having a meeting and they agreed.
So what enactment that was taken, was that a board resolution or not?
Your Honor, I'd have to look back to confirm, but I believe that it was a board action. It was a board vote that was taken at that time.
Okay, all right.
We spoke briefly about the standing argument, but I'd like to return to that. It was appropriate for the trial court to bring up standing as a threshold issue of justiciability. It's plaintiff's burden to establish standing, and she has not met it. The contract here that plaintiff is claiming is the 2006 amendment to the shareholder agreement, but as we've agreed, she's not a party to the 2006 amendment, and she admits that at most she was assigned a right to receive an annual payment, and that right, she also admits, was subject to the restrictions on the transfer of stock. The trial court reasoned that she can't hold the CVR stock and receive distributions. The annual payments in the 2006 amendment specifically provide that they're in lieu of the distributions. So as I previously explained, this invalidates the foundation of the 2006 amendment and her ability to receive these payments, and directly impacts her standing on this claim. Even if she could establish standing, as we previously discussed, Nick Vergos first breached the agreement, and she is therefore barred from recovering under the 2006 amendment. And even if she has standing and her ability to recover is not barred by the doctrine of first breach, which CVR contends it is, her recovery is limited further in two ways. And we discussed one of those ways, which is the 2006 amendment, the 2023 amendment, which terminated the 2006 amendment, which would limit her right to recover to simply that period at most between 2019 and 2023, but her recovery is further limited by the fact that the agreement clearly provides that the payment of the annual amount is subject to CVR having sufficient revenue to pay the amount. The board of directors unanimously determined on numerous occasions that it was not the case that it had sufficient revenues to pay the annual payment. Notably, plaintiff claims that CVR's revenues were abundant and goes so far as to question CVR's business judgment in providing modest wage increases to Rendezvous's hourly employees. Yet it was in the board's business judgment that it determined that it did not have these sufficient revenues. The Tennessee courts have consistently declined to substitute their judgment for that of the corporation's board of directors when the board has acted in good faith and for a legitimate purpose. There has never been any argument or allegation here that the board did not act in good faith or for a legitimate purpose. As we previously discussed, 2 board members even voted directly against their own personal interests on several occasions. So even here, if the court were to substitute its judgment, plaintiff's claims that things like government assistance received by CVR simply do not constitute revenues. In conclusion, Your Honor, we believe this court, Your Honors, we believe this court should affirm the trial court's grant of summary judgment in favor of CVR on all 3 claims. Thank you.
Thank you.
Very briefly, I want to get to the fact that there was mutual assent and consideration for the promise to pay Nick his bonuses every year during his suspension, but a few points that responsive to the statements just made. First of all, for clarification of the court, my recollection of the trial court, the probate judge's statement about bringing the cases down was not a request whether we were approved that or liked that or wanted that. It is, I'm going to have that done.
Well, let me pose a question to you. You were the plaintiff's attorney.
Right.
Initially. Could you have initially, if you had so chosen, filed this litigation in probate court?
I could not have filed the, I don't think I could have filed the individual claim in probate court. I could have filed the claim based for Nick's recovery of his bonuses. In my view, that could have been before the probate court originally.
Okay.
The second point I'd like to make is it's important, standing does not depend on the merits.
Let me ask you, you said the second case maybe you could have filed. Who would have been the defendant in that action that you think you could have filed in probate court?
That would have been Charlie Vergos Rendezvous for the non-payment of the bonuses promised to Nick. And the other action.
That's a corporate entity, right?
It would be the corporate entity.
Okay. All right.
standing, to be clear, is not dependent upon the merits. In the case of the Supreme Court case last year, the Supreme Court in fact held that there was no cause of action for wrongful foreclosure, therefore the defendant lost, but still the plaintiff lost, but the plaintiff still had standing. The claim that it's illogical to have an amendment that can't be terminated by the existing shareholders is simply wrong. You've got to recognize that the 2004 agreement provided certain benefits to Mr. and Mrs. Charlie Vergos, Charlie and Anastasia Vergos, and then the 2006 amendment at paragraph 4 said the annual payment shall be paid to Nick C. Vergos, John C. Vergos, and Tina Jennings, or to his spouse, if assigned to such spouse, for as long as either of them is alive. Now, what would be foolish and illogical would be to say, oh, but we're going to let any subsequent shareholders after we retire, they can change this and cut off the benefits. This was for all of their estate planning, and that's what both Tina Jennings and Jenny Vergos testified was the situation. Also, first breach was not pled, and there is, in Jenny Vergos's affidavit, she describes exactly what her husband Nick discussed with other people, and he was able to get two very successful restaurateurs to agree that they would serve on the board of directors of CVR if the other members of the CVR board would accept them. I see that I'm having to rely upon the arguments in my brief with respect to the mutual assent and the fact that Nick Vergos had to sign that resolution and return it in order for it to be valid, thereby signaling his assent to it. Thank you very much.
Thank you. Thank you both. We're going to take a short break and be back in just a few minutes.